Hello, one and all. Welcome to the Name Game, a presentation that will see us get into some potent information about your name, which you'll definitely benefit from in some way. And if you do let me know by leaving a like, share it with your chums, and do consider subscribing for more presentations just like this one. So without further ado, let's get straight into it. First up, to set the scene, let's look at the etymological root of the word name. It actually comes from the Proto-Indo-European word nomen, which evolved to the Proto-Germanic word naman, and later to the Old English nama or noma. So we can see the literal meaning of the word name is reputation, which is rather telling. Now let's look at the everyday English definition of name. So we can see that it refers to the word or group of words that is used to refer to a person, thing, or place. Now, this links quite nicely to a previous playlist series that we have done here before called Are You a Person? Because in that series, we get into the word person in loads of detail. So do check that out if you haven't already. But we do discuss that person, legally speaking, refers to either a legal person or a natural person, with a natural person actually being a sole proprietor. If you want to know more about this in its full detail, do check out that playlist. So why I mention this here is so you are aware that the person recognized in law is actually property that is owned, and things or places are also property. So the key aspect of all of these is that they refer to property, so something that has an owner. It belongs to someone. We tend to name things that we own, for example, our pets, our children, our belongings, things like this. Now, a law definition that can also clarify the meaning of name in a law context is this one, which reads, the designation of an individual person or of a firm or corporation. In law, a man cannot have more than one Christian name. So again, the name, legally speaking, refers to the natural person or a corporation, a legal person. Then a man in law cannot have more than one Christian name, which does make sense, right? I mean, you are given one legal name, as is evidenced on your birth certificate, which is used by you so that you can be recognized before the law. If you were to have multiple names, then it really becomes quite difficult to conclusively recognize you, and it also becomes quite an administrative burden on the government agents who are your trustees trying to administer the trust for your benefit, right? So it also makes sense from an administration point of view. So you may wonder, why do we actually use names? What are they good for, right? Well, there are a few reasons why names are actually quite a helpful tool for us. So let's just touch on those now. Firstly, the name helps us to distinguish between people. This is the most basic reason, I would think. Then they help us with communication. So if I'm talking about someone and I use their name, then you know exactly who I'm talking about just by me using the name, right? I don't have to describe them to you based on their physical appearance every single time. Also, when you are talking to someone, using their name directly, this actually brings about a great sense of respect and a deeper connection compared to when you don't use their name. Then you have that names can actually be culturally and symbolically significant. There are lots of names that have literal meanings, or they mean something in a different language, or they can be traditional and symbolic of certain values, things like this. And for some people, their name is actually a big part of their sense of identity and who they are, with some people holding this quite dearly and others not so much. But a key question that you need to consider in all of this is, are you your name? Or do you have a name? There is a difference between these two, which we will explore in just a moment. The question, are you your name, is really key because in actuality, you are a living man or woman, a spiritual and energetic essence, or what is commonly referred to as a soul, having a momentary human experience. So when you say, I am, and then followed by your name, you are essentially and energetically conveying the idea that there is no difference between the living you and the name that was given to you. There is no distinction at all. Your name is you and you are your name. You basically merge into one. Then the other question, do you have a name? Well, this is really key because when you were born, you were given a name from your mother and father, or maybe some other family member or a friend who was involved in the naming process, who knows? But essentially, you were given that name by someone else. This name is then evidenced on your birth certificate. The birth certificate itself evidences the given name that was given to you. This name is a tool that you use and you can take benefit from in a variety of different ways, some of which we actually discussed earlier. But the thing is, that name was given to you, which can only logically mean that you were still you before and after that name was given to you. So essentially, with or without the name, nothing about you physically changed. So this shows you that you are not the name, but you have a name. You can actually choose to use your name or not. Heck, you can even change the name if you don't like it. Again, this shows you that you are not the name, but you have a name. The name is nothing but a tool, and this tool you use to actually do many things, especially when you're interacting in the legal world to get, for example, government ID, to enter into contracts for goods and services, and also so that you are able to have a legally recognized personality, so a natural person, or also referred to as a sole proprietor, to be able to legally own property in that name. So the question becomes, to be or not to be? That is the million-dollar question. Are you your name or do you have a name? The difference here is that on one side, the side where you are your name, you and the tool that is your name are one. It is almost as if you are the tool getting used by other people instead. Hence, loads of problems are likely to come your way on that side of town. Then, on the other side, the do you have a name side, you have a tool which you can use for your benefit, seeing as it was given to you, right? So you can actually do and create lots of different things out there in the real world as well as the legal world. So let's touch on who actually named you. It is quite obvious that you did not just emerge into this world with a name. The name is not a tangible thing that exists in the physical world. It is not attached to you, nor is it written on you when you are born. It is actually your family or your family friends who take part in the naming process. And ultimately, it's your mother and your father that then give you that name. Hence why it is known as your given name. So essentially, you have relied on other people to tell you what your given name is, right? You don't actually have first-hand knowledge of this process, as you didn't name yourself. So technically, you are going off of the information that others have given you, which means that when you talk about your name, it would actually technically be considered hearsay because you don't actually have first-hand knowledge of the facts relating to your naming process. Now, given name, isn't that a funny way of telling you your name is gifted to you? But let's think about it being gifted to you through the mechanism of a trust. Hear me out. So, the settlers are very clearly going to be your mother and father. I mean, they created you, so they also give you a name. But ultimately, the name they come up with, which is going to be used to refer to you, this name is actually their copyright intellectual property, which they can then settle on trust for you. They won't be using it for themselves. It is for you ultimately. But when you are born, you are too young and really you're incapable of knowing what any of this means, right? You still have to grow up and learn the ways of the world. So during that time, your mum and dad, well, hopefully they will take up the role of trustees for your name. They will act out their trustee role by registering the name and also administering the name throughout your childhood years. And they also pay for all your bills too, and this is even enforced in law, right? Otherwise, if your mum and dad, if they don't do a good job as trustees, well, the state can actually come along and take the child away, all with the reasoning that it's actually for the best interest of the child, even though sometimes this isn't totally correct. Then you have the beneficiary of this whole arrangement, which is the living you, the sole beneficiary of the name that your mother and father have given you. But the interesting thing is that once you become of age, so you are age of majority, and you can actually now begin to interface in the legal world, all of a sudden you can actually use, keyword being use, right? Which shows you the beneficial title in existence. You use the name with a surname specifically to get a job, to enter into contracts in your own name, and to own things in your own right. You can gain property, you can receive certain services, for example, services that the government gives you directly, and many other things that you could not actually do prior to being of legal age and being able to take charge of your own name and the surname. So hopefully this has shown you quite clearly in a visual way that your name and also the surname, it's actually not your property as such. You have beneficial title to it, so you have the right to use, but the name is not you. So we touched on this idea earlier that you do not have first-hand knowledge of your naming process. And in actuality, you just take your family's word as fact without really knowing any different. So technically speaking, you don't actually know your name, at least not with first-hand knowledge. Yes, you do have your family as witnesses to the process, and even your birth certificate records, they provide you proof of the name. But essentially, you cannot actually with 100% certainty say that your name is whatever your name is without engaging in hearsay in some form, with hearsay just referring to information that you have heard from someone else and you do not actually know if that information is true or not because you just simply don't have first-hand knowledge of the facts of the situation. And believe it or not, hearsay is inadmissible as evidence in a court setting. So it is not accepted in a court of law unless there are certain exemptions to this. But generally speaking, hearsay is not accepted. So isn't that interesting though? You use the name all the time. You even say you are called that name or you are that name. But did you realize that actually you don't have first-hand knowledge to know if that is true or not? So we've established quite clearly by now that you are not your name, but you have a name, and it has been given to you. So this shows us that your name is used to represent you, right? It's used when referring to a living man or woman, but the name in itself is not you directly. The name is used to represent you. The word represent is key here because, as you can see on the screen, a definition of represent is to be a sign or a symbol of something. So it shows you the name is just a group of words used as a sign or symbol of the real living you. But we can logically see that the name represents you. It acts as a sign of the real living man or woman that you are. It's also good to note here that the are of represent. The re prefix is actually a really important aspect of this word. So re as a prefix refers to doing something again. And you can see this in examples such as replay, rebuild, rearrange, those kinds of words. Well, when you are being the living man or woman that you are, you're just presenting yourself, right? You are just being who you are. Your face is your identity. Your physical presence is proof of your existence. And the fact that you can take part in inward and outward action is proof that you are alive in the 3D world. However, how exactly do we translate all of this into the 2D world, into the world that exists on paper through written words and pictures? Well, the only way is to have a different form of you which can exist on the 2D plane of existence. 3D you cannot just poof, turn into a 2D existence. That is not possible. But what is possible is to create something that can exist on the 2D plane of existence, which is then used to re-present you. So to present you again in the 2D format. I hope this is making sense for you and helping you to really grasp the differences between you and your name quite clearly by now. Now let's get into your name and its significance in a court setting. So in a court setting, one of the first things you will be asked to do is to state your name for the record before you can even speak, so before you have the right of audience. So if you were to go ahead and just say, I am, and then followed by your name, believe it or not, you would actually be lying straight from the beginning, just like that. This is really key because you are setting yourself off on a really bad foot. You could even be considered to be in contempt of court from the beginning because you are lying to the court. And in which case, do not be surprised if as a result you feel that the court is completely against you and just looking to just completely punish you in whichever form they want. How are you lying exactly, you may be wondering? Well, you are using general language. You are not being specific about who you actually are in relation to your name. Remember, it is a creation given to you as a gift. You existed before it, so how could you claim to be it? What you really should do is express that you are the beneficiary of that name, the sole beneficiary to be exact. If you do not express this position from the get-go, then it actually may be that the situation and your choice of words and your choice of actions will actually be construed as you acting as a trustee for the name, which is totally wrong because you are the sole living beneficiary, right? If you do not express this, then your actions will most likely be construed against you. In other words, you will be treated as a trustee de son tort, so a wrongful trustee, and this will most likely than not be used to justify any punishment or harsh order that the court gives you, right? So what could you say instead then? Well, here is my suggestion. How about when you are asked, what is your name and address? Before you start actually giving the name and the address of your home, how about you deal with things in a different way? You could say, for example, I am the sole living beneficiary of the name, and then insert your name here. You can address me as beneficiary. I can provide proof of my beneficial entitlement to this name in the form of the birth certificate and photo ID. I can be located in my body that is present before you. This suggestion is actually 100% truthful on your part, and it is setting you up nicely for the rest of what is yet to come. You can, of course, make your own variation of this suggestion and really get creative as much as you like, but essentially, if you do not say something along the lines of this suggestion, then you would actually find yourself misrepresenting the facts of the matters straight from the beginning, when it matters most to make a good impression. And as a result of misrepresenting the facts, you could be considered to be acting fraudulently as per the Fraud Act of 2006, which would be a big no-no. But let me warn you, it is unlikely that judges and magistrates will receive this approach kindly. I mean, they are trained in a specific way following a specific script, and you not following it makes their life much harder. And they probably do not like to improvise their lines, nor are they prepared for the improv. But fear not. You must not shift from your position at all costs. Do not be tempted into lying or making a false representation, whatever you do. If things do become a little tense and maybe a judge or a magistrate becomes quite hostile towards you, then you can always remain as calm as you can and say something along the lines of, respectfully, if I claim to be anything else, I would be lying, and it is my intention to tell the truth. It is not my intention to fraudulently represent facts, and I do not accept any offers to commit fraud. Thank you. This is a clear way of setting your boundaries, especially when you have said all you needed to say, and especially as you will not be shifting from that stance. So I mentioned that if you say something else, you could be considered to be acting fraudulently as per the Fraud Act. So let's just see which sections could actually apply and how they could apply. Now, a quick side note here before we start. Yes, this act, like all acts, apply to a person. And if you've watched my previous mini-series called Are You a Person?, you may already know that living you is not a person, as per the current legal statute definition of the word. However, do bear in mind that as soon as you lie or commit fraud, then unfortunately, most likely than not, the system will probably hound you regardless of any sort of argument or explanation that you may have as to the word person and its application to you specifically. When fraud is involved, wriggling your way out of that with the defense of not being a person is likely to be overlooked by a court judge or magistrate. So this is why I emphasize the importance of being truthful and not lying or misrepresenting the facts to avoid having serious issues at any stage of your dealings with the legal system. But essentially, to illustrate what I mean by your name in court, let's look over section 2, fraud by false representation. So subsection 1 reads as follows. 1. A person is in breach of this section if he A. dishonestly makes a false representation, and B. intends by making the representation I. to make a gain for himself or another, or II. to cause loss to another, or to expose another to a risk of loss. So how does this apply to you exactly? Well, when you fail to express the specific truth about the name and the hidden trust relationship, meaning you are acting as trustee de son tour, then you are actually putting yourself in the position as beneficiary at risk by lying about your true essence and your rightful and lawful position as the beneficiary only. In terms of subsection 2, it states that a representation is false if A. it is untrue or misleading, and B. the person making it knows that it is or might be untrue or misleading. So now that you have evidence and knowledge that is contrary to the standard approach to things in general, you are actually bound by your conscience to express the contrary evidence and knowledge. By the very fact that you now know that if you say, I am, and then your name, this is actually untrue for all of the reasons we have already discussed, then you indeed would be making a false representation, as this section states. Then under subsection 3, representation is defined as any representation as to fact or law. So you see how broad this definition is. A representation as to facts about a certain matter or about the law itself. This covers literally anything, including the facts regarding your name and the fact that your name was given to you under the mechanism of a trust and therefore is governed under equity law. And just notice subsection 4, it states that a representation may be express or implied. So you can make your representation expressly, so by words written down or orally, or it could even be implied by, for example, your conduct, or even from the presumptions that are used and just exist naturally in law, which you fail to rebut. Are you starting to see how things go now? How about section 3, fraud by failing to disclose information? So this section reads, A person is in breach of this section if he A. dishonestly fails to disclose to another person information which he is under a legal duty to disclose, and B. intends by failing to disclose the information to make a gain for himself or another, or to cause loss to another or to expose another to a risk of loss. So you can see that once you know the facts, you then are under a duty to express them, because if you fail to do so, then again you are putting yourself at risk as the beneficiary. The risk being that you run into being construed as the trustee instead, which we all know that the trustee is always the one who's liable to make disbursements or make payments, and will always be the one bound to act in a certain way for the benefit of someone else. Then on to section 4, fraud by abuse of position. This section reads as follows. A person is in breach of this section if he occupies a position in which he is expected to safeguard or not to act against the financial interests of another person, dishonestly abuses that position, and intends by means of the abuse of that position to make a gain for himself or another, or to cause loss to another, or to expose another to a risk of loss. So subsection 1 is key really, because when you fail to assert yourself as the beneficiary of your name, then this position will become up for grabs, which the judge will most likely gladly take for you. Why is that? Well, your name is property, remember, and it was copyright protected intellectual property of your mother and father. So it is property, and property cannot be void of an owner. So the doctrine of bona vacantia will kick in silently in the background, hence why when you fail to claim the beneficiary position, the judge can come along and claim it on behalf of the state or the crown. And in doing so, the judge not only will be in position to punish you as the construed trustee of your name, but also they will be in position to punish you for abusing yourself when you should be in your lawful position as beneficiary only. Then subsection 2, a person shall be regarded as having abused his position even though his conduct consisted of an omission rather than an act. This shows you further evidence that when you fail to claim your beneficial entitlement to your own name, which could be considered an omission on your part, when you are actually in a situation where this information is absolutely critical for you to express, especially to the trustees, which are the magistrates and the judges who represent the state or the crown as the public servants that they are. When you fail to assert your beneficiary position and instead you start to act like a trustee, you are failing to protect your beneficial interests, making them completely up for grabs, and really opening yourself up to being abused by others who will definitely seek to exploit your lack of knowledge and your lack of claim. Now, let's touch on the full name. So the full name refers to any first names, middle names, and surname, and sometimes with the addition of a title like Mr. or Mrs. added in there for good measure. However, in your day-to-day life, it is pretty rare to have people refer to you by your full name, right? This is because this tends to be long and impractical, and essentially nobody has the time nor the patience for this. There are a few limited circumstances where it may be useful to use the first name and the surname. Say, for example, you are talking to two people who both have the same first name. Then in that case, you may indeed use their surname to differentiate between these two people quite easily. But generally speaking, the full name is used only when we are dealing in the legal world in some way, where there is some sort of contract or an agreement at play or being offered to you. There's a reason for this, and it all has to do with the value of your name in a contract-based system. Let's put it this way. If someone is asking you, "Are you?" followed by your name, your first thought should definitely be to question who is asking. This is because your name is extremely valuable in a contract, commercial, and completely debt-based system. Why do you think it is that the first thing they would ask you in a court is for you to state your name? Your name in the hands of someone who does not have your best interests in mind could literally spell disaster for you, because it is very likely that whoever is asking for your name is looking for it to be able to contract with you in some way, and I bet you it won't be for your benefit. I said your name is extremely valuable, but why is it so valuable, you may ask? Well, it's because your name is worth gold, literally. How exactly, you may ask? Well, if you have watched the Truths You Haven't Been Told About Trust series, then you may already know. And if you haven't seen it, then I do recommend you check that out, because we get into some really important knowledge in that series, which links really nicely to this topic right here. Your name is worth gold because your name is literally used to signify or represent the beneficiary of the trust relationship that is inherently in existence within the current monetary system that we have in place, which has resulted from the abandonment of the gold standard. It is the name that you were given which the government uses to actually be able to identify and recognize you, the living man or woman, before the law, who is the individual who is supposed to be one of the beneficiaries of the monetary system trust. And of course, the gold that is still physically in existence at the central bank. This is why the name is literally worth gold, because we all have a percentage share in the physical gold that still exists. It's all about who is claiming which position in all of these trusts that are at play. What happens when you are unable to express yourself as the beneficiary of all these trusts? Well, your beneficial entitlement becomes up for grabs, just like lost property, at which point anyone can claim it for themselves, like a pirate claiming lost cargo under a salvage operation. So, in which ways could your beneficial entitlements become up for grabs? Well, there are a few ways. The most common and the most obvious is when you fail to express who you are in the trust relationships. Another way is if you show signs that you are incompetent to handle yourself properly. For example, you do not speak for yourself because maybe you have others speak for you. For example, when you allow a lawyer to speak on your behalf. And one of the most potent ways is when you are inactive in claiming your entitlements, which will allow others to presume that you're dead. I know this all seems a bit crazy, but remember, actions speak louder than words, and inaction is a form of action in a way. Inaction also being a form of death, right? The end of something permanently. When your beneficial title becomes up for grabs for whatever reason, then it becomes subject automatically to the doctrine of Bonaventure in your absence. It will vest to the crown by operation of law, and at that point you can essentially wave goodbye to your property rights. But hold on, not so fast there, buddy. There is a way out. This will all be true until you are back in action. When you have educated yourself on the hidden trust relationships and what this all means for you personally, and all the contracts you thought you were in, all of it, you will be able to return to activity and begin to claim your rightful entitlements again. And when you do so, your rights are reverted back to you. I mean, this is what the Sesquiv Act of 1666, which by the way is not repealed, and also the Presumption of Death Act of 2013, specifically the part about exceptional circumstances around the return of a presumed dead person and their estate. This is what both of these acts actually support. So you may be wondering, how exactly do you return to activity, return to action, and actually start claiming your beneficial entitlements? Well, there are a few ways to do this. Number 1, you begin to express the hidden trusts and assert your lawful position as beneficiary. 2, you make the fully informed decision to stop acting as trustee de son tort. 3, you speak for yourself, and you make the active decision not to allow others to speak for you. 4, you take responsibility for yourself. and you commit to not harming yourself any longer in your position as beneficiary. 5. You actively seek to express your presence as beneficiary to the trustees who need to know this information. For example, judges, different government departments, constructive trustees, literally everyone who you can think actually needs to know this information. 6. You revive from your presumed death due to your previous inaction, and now you begin to declare that you are alive and back in the game. I think it's time to start having some fun. Won't you agree? So this brings us to the end of this presentation, and let's just recap what we've gone over. So we've gone over the etymological root and law definition of name. We've gone over the benefits of using a name. We've discussed how your name is actually your tool. We've shown you the fact that your name is given to you as a gift. We've discussed how your name is key in court settings. We've shown you that the full name is a tool to contract with. We've discussed the value of your name and what it represents. And we've discussed how you can begin to activate your beneficial claim. So this is game over for this presentation, but the game is just getting started on your revival of your beneficial title claims. I hope that this presentation has helped you see the reality of your name, how you're not actually your name, but you have a name, just like you're not a person, but you have a person. Hopefully you can see as well the importance of educating yourself in this knowledge to make sure that you are expressing yourself in the most truthful way every single time that you interface with the legal system using your name. If you enjoyed this video, I hope you'll consider leaving a like, sharing it with others, and subscribing if you haven't done so already to really help out this channel and enable this knowledge to reach as many people as possible. Thank you for your support, and I shall see you in the next one.